What we're going to be looking at today is essentially sort of five relatively discrete topics that relate to various aspects of litigation funding. As a whole, of course, it covers a vast array of subjects from CFAs to ATE insurance, liability of non-party funders, and so on. So what we're going to focus on this morning, or afternoon or evening, is as follows. Firstly, obviously, we've had in relation to solicitor-owned client disputes, generally in relation to CFAs in terms of reported cases, the Court of Appeal decisions in both Belsner and Karatsit. And so we'll look at the facts and the decisions in both those cases relatively briefly, but also the ramifications for the future of solicitor-client disputes following those two decisions. Secondly, we'll look at the pros and cons of various funding models, and principally in that context, CFAs, contingency fees, or damage-based agreements. Thirdly, the current state of the case law for DBAs, which very much relates to the second point, including the most recent sort of cases of Farrer and Candy Limited. Fourthly, we're going to look relatively briefly at non-party costs orders against third-party funders and the current state of the case law in that regard. And finally, for those of us who wish to sort of go it alone without the benefit of either ATE insurance or the form of litigation funding, potential liabilities of legal representatives where a claim is effectively self-insured. So finally, if you don't want all of the restrictions of having a litigation funder or restrictions imposed by an ATE insurer, and you properly inform the client as to all of these potential options, what if a legal representative is willing to take the risk of self-insuring adverse costs? Noting that is actually the position as it's emerged during the course of the skirmishing in the Slater and Gordon litigation. That is the way in which Clear Legal, Check My Legal Fees, operate in their own agreements with clients bringing solicitor-owned client disputes. Now, such arrangements have been open to a series of challenges over the years, and really the most significant case law goes back to sort of 2013, which sort of sets out the parameters as to what is and what is not sort of legitimate in those circumstances. In Heron and TNT UK Limited, the solicitors acted on a CFA in circumstances where there's no ATE in place. On the particular facts of the case, the application for a non-party cost order failed, applying obviously a non-party cost order against the solicitors, applying the usual test as to whether or not the third party had become a real party to the litigation.